नहीं है, तुझे बहुत आगे जाना है। जिन्होंने कहा था तेरे बस का नहीं है, उनको भी करके दिखाना है। तो इसी मोटिवेशन के साथ
Madam, this court cannot be a legal advisor. You can knock the door of, in respect of seniority, promotion, selection within 6 months, reasonable period.
They should be seen in
Ranking.
equal spectrum, my lord. They
So
should
shall
be
I
seen.
record? You want me to record?
My lord, the present petition has been filed, my lord, challenging the order of the Honorable Cat Bench, Patna, your lordship, in OA number 50 of 2015. My lord, inadvertently, your lordship, the
What is
order
the date of the impugned order, madam?
my lord, inadvertently, your lordship, the impugned order has not been attached with the main petition, my lord. For that purposes, I filed the
No,
supplementary
I am asking
affidavit.
you what is the date
Yes,
of the
my lord, I
impugned
will
order?
provide the date, your lordship. 5th April 2019.
Huh?
5th April 2019.
Where do you get on which page number?
Yes, your lordship, that is what I was saying, my lord. The impugned order has not been attached with the... For that purpose, my lord, I have filed a supplementary
So you
affidavit.
reject this petition.
My lord, I have... my lord,
Since you have not produced the impugned order.
My lord, right now I am producing it, my lord. I have filed the supplementary affidavit, your lordship. Inadvertently, my lord, could not be attached with the main petition, my lord. This is the supplementary, my lord, attaching the impugned order.
No, OA is rejected, no?
Yes, my lord,
On
OA
the
is
ground of
rejected.
delay.
Yes, your lordship, on the ground of delay.
Then what else?
My lord, petitioners are, your lordship, similarly situated person, my lord. My lord, may kindly see annexure 1. Annexure 1, your lordship, of the main petition, my lord.
No, what was the relief sought by you before the CAT?
My lord, the relief, your lordship, me, my lord, the petitioner, along with other similarly situated person, my lord, they applied into 1978 advertisement, my lord, and the appointment has been done on in 1988. Some of the persons, your lordship, including the petitioners, your lordship, delay of 10 years, my lord, which has been caused by the railway department itself, not from the side of the petitioners, your lordship. Thereafter, my lord, some person have approached before the honorable cat bench, my lord. They have been given the relief, my lord. That particular order has been challenged by the department, your lordship, by way of filing a writ petition before Patna High Court, my lordship.
When were you appointed?
My lord, I was appointed, your lordship, in 1988.
1988.
Yes, your lordship. Advertisement, no, my lord. It's not that about advertisement, my lord. The related benefits, my lord, which has to be given. I was appointed in 1988.
Give me the date, exact date.
1/11/1988.
1/1?
1/11/1988. So my name was included in the panel which has been published in 1/11/1988. Although the advertisement of was 1978, your lordship, but due to the technical defect from the side of the department, my lord, I have been appointed, my lord, in 1988, your lordship. So others people, they have approached other department, not me, my lord, not from my department, from the other department, arising from the same advertisement, my lord. They have approached before the honorable cat bench, your lordship. They have been granted the relief, and that particular, and the department, my lord, thereafter filed a writ petition, your lordship. I was not at all aware of all those things, your lordship.
Please read para 8 onwards.
Of my petition.
Of order.
Of my petition.
Of order.
Order. Impugned order.
Tribunal order.
Moreover, the respondent vehemently pleaded that the present OA is hopelessly. Yes, my lord, that is what I was explaining, although I'm reading that. Since they are claiming their seniority from the initial appointment, that is 1980-81, they could have raised their grievances before the authorities in 1988, 89, 96, 2001, when 4 cases bearing such and such number were filed, but the applicants failed to do so. Heard the learned counsel for the parties and perused the record, the tribunal has noticed that admittedly the applicants were appointed in different categories of class 3 posts, although their selection was made pursuant to the examination conducted in 1980 and 81 by the Railway Recruitment Board Muzaffarpur in response to the advertisement number 9 of 1978 dated 11/6/1978. But their seniority must have been maintained in their own categories. It is further observed that the grievances of the applicant pertains to the year 1980-81 as per their own submission. If they were really aggrieved, they could have raised their grievances before the authorities, at least before 1995, which they failed to do so. Certainly it is a stale matter and is hopelessly barred by the limitation. So this was the ground taken by the Honorable Cat Bench, my lord. But my submission would be, your lordship, since I was not in knowledge of that, your lordship, other department person, they have approached before the court, they have been granted relief, and the department has gone before the Honorable High Court, my lord, and their petition has been dismissed, your lordship. On that basis, my lord, 2015, my lord, in 2015, these people have got the benefit of that, my lord. So, my lord, no question of limitation from my side, your lordship. How could I be affected by that?
You were aggrieved party or not?
Although I was agreed party, my lord,
Why
if
you should be.
All right, that's all. That's
my
all.
lord, one more submission I would like to make, your lordship. My lord, paragraph number 14 of the main petition may kindly be seen, my lord.
Yes.
So, your lordship, since the cause of action has arisen and it has come to my knowledge from that day itself, my lord, the cause of action will arise from my side, your lordship.
Cause of action arises when someone gets that benefit.
Yes, my lord, they have got
Not when you were denied that benefit.
the benefit in 2015, your lordship. That is what my submission is, my lord.
All
So,
right.
after that, I have come to the knowledge of it. Thereafter, I have approached before the authorities, my lord. I am putting question to myself, your lordship, whether similarly situated person will get the relief. I will be taken aback because since I have not approached the authorities for that purposes, my lord, same criteria should be maintained for everyone, your lordship.
Yes, take down. The instant petitioner has assailed the order of the tribunal dated 5th April 2019, passed in OA 930 of 2015, passed by the Central Administrative Tribunal, Patna Bench, Patna. The petitioner and others were candidate for recruitment to the post of class 3, like guard, commercial clerk, trains clerk, office clerk and accounts clerk, etc. In this regard, examination was advertisement was issued in the year 1978. Examinations were conducted in the year 1980 and 81 by the Railway Recruitment Board, Muzaffarpur. The petitioner was selected and appointed on 1/11/1988 to stop. The grievance of the petitioner is that petitioner is entitled to benefit of fixation of pay, seniority with reference to the merit list published irrespective of the date of appointment, and to assign seniority and fix notional pay. The tribunal rejected the petitioner's grievance on the sole ground that there is a delay. In para 10 of the order, tribunal held as under. Next, counsel for the petitioner vehemently contended that when similarly situated persons who have been extended benefit in the year 2015,
Yes, my lord.
and the petitioner is also entitled to have the benefit of seniority with reference to the decision rendered in OA number 306 of 1988 and connected matter, which has been quoted in para 8 of the tribunal order. In para 14 of the petition, the petitioner submitted that if any judicial pronouncement is passed in favor of an employee, the same is required to be followed by the employer and extend in respect of similarly situated person. Therefore, the tribunal has committed error in not extending the benefit on par with others who are similarly situated person. Heard the land counsel for the petitioner. Undisputed facts are that the advertisement number 9 of 1978 was notified on 11/6/1978. Among others, petitioner was a candidate and selected and appointed on 1/11/1988 for the purpose of rectification of the seniority and notional fixation of pay. The petitioner has presented OA in the year 2015 to stop. Perusal of the records, it is evident that petitioner had a cause of action in the year 1988 or within a reasonable period of 3 years from the date of appointment. The petitioner was aware of the date of appointment and ranking in the select list. If there are any errors in that event, such errors are required to be agitated before the appropriate forum within a reasonable period of 3 years. Whereas the petitioner seems to be a fence sitter for the reasons that his grievance has been agitated for the first time in the year 2015 with reference to earlier decision of the tribunal in respect of a similarly situated person who is stuck. Next, the petitioner cannot have the benefit of similarly situated persons had benefit of a judicial pronouncement after a long gap of 15 years. Moreover, apex court in the case of P. Sadashiva Swami versus State of Tamil Nadu, reported in 1975 so and so, read with Vijay Kumar so and so, held that in respect of selection and appointment and seniority and promotion, the aggrieved person must approach within a reasonable period of 6 months from the date of cause of action accrued. In the light of the apex court decision cited supra, the petitioner has not made out a case so as to interfere with the order of the tribunal dated 5/4/2019 passed in OA number 930 of 2015. Accordingly, petition stand dismissed.
But my lord, my contention would be, your lordship, other person, they have also approached in late form, my lord. They did not approach at that point
Have
of
you
time. my
implemented
lord.
them as party?
No, my lord, I have not
Then-
implemented them. If my lord will suggest, I will implement them as a party,
why
but
should-
my
why-
lord,
why-
because my lord, there is no fault from my side. They have taken 10 years time, my
Madam,
lord, for the appointment.
Madam,
The technical delay was from their
it
side,
is
your
your
lordship.
case. This court cannot suggest to you to do like in this manner. This court cannot be a legal advisor.
My lord is correct, your lordship, but 10 years, my lord, delay has
Sorry,
been caused
madam.
from their side as well, my lord. Technical defect was from their side, my lord. They have given me the appointment in 1988, my lord, of which the advertisement was of 78, your lordship. It was delay from their side, not from my side, your lordship. Then also I kept on working, my lord. When other people, I do admit that, my lord, ki other person, when they were given when they did come to the court, I was not one of
Madam,
them, but
Supreme Court has clearly laid down a principle. At what point of time you can knock the door of, in respect of seniority, promotion, selection, within 6 months, reasonable period.
But my lord, other persons are working, but
Correct.
they are getting the benefit, my lord.
You should have challenged their promotion or
They should be seen in
ranking.
equal
Have you
equal
challenged?
spectrum, my lord. They
So
should
shall
be
I
seen.
record? You want me to record?
No, my lord. But my lord, they should be seen in the equal
All right,
spectrum,
I
my
will
lord. That is
record.
my.
I will record if you want. But subject to payment of cost.